Okay. Right. I had been silly. I had pressed the wrong button. Right. Welcome. Sorry for the slightly late start. I had not clicked the broadcast button properly. I was trying to work out what had gone wrong, and that was me. So my apologies for that.
I've joined in now.
Okay. No, that's all right, Hans. I hadn't pressed the right button. So okay. We are now all live and people are beginning to join us.
Yeah.
So welcome. We have Alicia and Asman and Christine and Mary and others, Rumi, Violetta, all welcome. This is a joint OTS 36 group webinar to, I think it's fair to say it's mostly pitched at employers, and we're dealing with really preparing for post-COVID-19 and the world we're currently in at the moment. So I'd like to welcome you all. Thank you for coming. We've got a good few numbers come on now. Just to draw to your attention in the interface, there is a button with more, and if you click on that, there is a chat button. If you click on that chat button, that's how we'll be able to talk through the presentation. And if I could just ask you to look at the two, you will see that you have a drop-down menu, and you can choose all panelists and attendees. If you choose that option, you can then type, and everyone will see it. So I'm going to type in a message. And hopefully you'll see that, and that's how, if I can ask if you have any questions, to please drop them in that. I'm going to monitor it, and Hans will probably monitor it as well throughout our sessions. If you do have any questions, please get stuck in and ask them. So without further ado, I'm going to start by saying that, of course, that we've had some developments in terms of lockdown yesterday, in as much as we've had some announcement from the government. Now, whether that announcement was as thorough and detailed as perhaps we might have liked is a subject we could probably have a long discussion about. But it does seem that the government doesn't fully know how it wants to deal with this at the moment. And so the presentation plan the government put forward yesterday was a little vague, I think it's fair to say. Essentially, lockdown will be carrying on through the rest of this month. Apart from the fact we're allowed to go out more than once or twice to exercise. And then in June, it looks like they'll be thinking about opening schools up a little bit, and some entertainment, hairdressers and so on will be opening up in July. So it does seem that we're in for a pretty long haul in terms of lockdown. All those of us who were hoping the government would allow business back to usual, I think are going to be a little bit disappointed with the announcement yesterday. Although Boris Johnson said that we can all go to work if we can't work at home, I suspect there isn't much work for people to do with everybody else at home and no one spending any money. And that will be a theme, I think, of our presentation today, which is how to manage matters going forward in this very uncertain and difficult climate. One thing I'm not absolutely clear about is what's going to happen with the furlough scheme, and we're going to be talking about that in a bit more detail later on, but there was no announcement with the government's announcements yesterday on furlough. The Business Secretary and Chancellor have both suggested that it's going to be ended pretty soon, although the Telegraph, as Hans was telling me earlier, suggests that it might be continued on until September. We just don't know. And the fact is that estimates are that it's a huge amount of the workforce currently on furlough, and if the government are going to carry on paying for that until September, the cost will be absolutely staggering, which leads me to think that perhaps the government will be looking to phase that out sooner than the lockdown will be phased out, which will put an awful lot of businesses in a very significant cash flow issue. And that's something we're going to be talking about throughout today, which is preparing adequately for these sorts of issues. So we've got a rough agenda for today. We're going to be talking about furloughing. Richard and I will talk about that. Tenny from OTS will be talking a bit about redundancies. I'm going to give a very brief overview of what the government measures are to help businesses, which I imagine you all know about and have all implemented. And Hans also has a presentation on post-COVID-19, and then we'll have some concluding remarks. So please all ask your questions in that chat box, and with that I think we'll start. Richard, would you like to kick off with a little word on our favourite subject of furloughing?
Yes, indeed. Thank you, Simon. I'm just going to share my screen with you all, so you'll be able to see some slides I prepared. I stress that slide preparation is one reason why I became a lawyer. To begin with, then, we should note the very broad coverage of the scheme. It really breaks down many of the barriers between different categories of workers as they previously existed. So you can be furloughed, admittedly by the agency, if you were an agency worker, whereas previously agency workers had very attenuated rights. Furlough monies can be paid to foreign nationals who would not otherwise be in receipt of public funds. Again, a symptom, a sign perhaps, of the gravity of the situation. The key requirement, however, is
Sorry to interrupt, Richard. Someone has rightly pointed out they can't see the slides.
Oh, well, my... let's have another look. I thought that had worked, but let's... Has that done it?
Yes.
Great. Beg your pardon.
Thank you, Fatima, for pointing that out. Yes, sorry, carry on.
I do apologise. There in slide 2, we have the enumeration of the various categories of people who can be paid through the furlough scheme. But the key thing is that you have to have been being paid through the PAYE scheme at the designated date. What do you get? Well, that's shown by my next slide. You get 80% of your gross salary, you're taxed on it, or you get 2,500 gross, whichever is the lower. Even if 80% of your previous salary takes you below the national minimum wage. So the scheme, whilst broad, is not particularly generous, and perhaps unsurprisingly. One of the aspects of the scheme which has been very striking is that you can't claim any furlough monies if you are on very reduced hours with your employer, even if your reduced payments are less than 2,500. That is a black and white rule which has some pretty unfair consequences, and one of the things that's been announced recently is that the government are looking at that as a possible change, hardly surprisingly. One question I've asked myself is why wouldn't an employer furlough staff who were not needed due to the coronavirus problem? And in particular, the question of whether an employer can furlough people even if he, she, or it knows that they will never be able to take them back, because the impact on the business of the virus has been so extreme. That is sometimes advanced the reason on the part of employers for making redundant rather than furloughing. I've thought about that very carefully on the part of some clients, and I think the premise is wrong. An employer can furlough someone even if they think they are not going to be able to take the employee back. And one way in which we know that is that employees who were made redundant before the scheme came into effect in February can be re-engaged, which shows that redundancy and furlough are not incompatible. So the scheme then is not limited to people who are being laid off for a period and who are then going to be taken back. Another reason why some employers, I think, are reluctant to furlough is the cash flow point. And that's a good point, or it would be, but for one thing, that in its most recent webinar, and I do commend the HMRC's webinars to those watching, the HMRC made it very clear that people could claim furlough monies from HMRC sufficiently in advance of payroll day to allow the money to be in before it has to go out. So at least as recently as the last couple of weeks, there need be no cash flow problem in relation to furloughing. There are some alleged hidden and possible hidden costs to the scheme. One would be that an employee who furloughs a number of employees might well find himself in a situation where significant amounts of holiday pay had accrued. That's because finds himself in that situation at the end of the furlough period. And that will be a disincentive if the employee decide at that point to make redundant. That difficulty arises from the fundamental feature of the scheme, which is this, that save that the employee is not required to work and gets less than full pay, the furlough scheme, that the contract of employment continues throughout furlough. So everything else, apart from the obligation to work, ticks along, including the accrual of holiday pay, including sick pay, if that is an eventuality. And so too with holiday pay. I'm going to move now to the next question, which is, and deal with this briefly, because as Simon has said, the furlough scheme may be being wound down in the next few weeks. And the question is, are employers obliged to furlough? Can they incur any legal liabilities for not doing so? And the answer to that, in my view, is resoundingly yes. It may be unfair to dismiss an employee for redundancy when at virtually no cost to the employer, he or she can be put on furlough and rescued from penury instead. And there may also be some Equality Act liabilities around female employees and older employees looking after elderly relatives. And I'll return to those in a minute. But as Simon has said, we may be moving, or may not be moving, to a post-job retention scheme world in the next month. What will that world look like? Well, as I've indicated, the normal incidence of the contract of employment will have ticked along. So some employers will undoubtedly find that employees who before furlough had no unfair dismissal claims have now been in post for 2 years and therefore cannot easily be dismissed. That will be an unpleasant surprise, perhaps. The most challenging issue will be when a business reopens and needs some, but not all of the staff who are on furlough. That will raise questions of which to keep and which to dismiss for redundancy. And it's pretty standard law that in that situation, the employer will have to have fair criteria for selection, and to select fairly, and to consult generously, or to consult appropriately with employees, at least in the case of those who have more than 2 years service. But even if they don't, once again, there is the problem of the Equality Act from employers' perspective. An employer will need to be able to show that those with protected characteristics under the Equality Act were not first in the queue for redundancy, particularly perhaps and most heinously if they had childcare responsibilities. In the case of larger employers, the provisions of the Trade Union Relations Act of 1992 will be relevant. There's an elaborate procedure for consulting about large-scale redundancies, which may feel very burdensome to employers in the rather frantic decision-making that will inevitably fall to be made post the retention scheme. More broadly, however, and indulging here in a little bit of crystal ball gazing, you may well have heard when discussing with friends or colleagues over Zoom or watching on television speculation about whether the world of work will be fundamentally altered even when the virus disappears or in the process of disappearing. In practice, what that means above all else is, will there be a reorientation of work towards home and electronic working of the sort which we have become familiar with over recent weeks? Put it colloquially, will the 715 from Berkhamsted have as many people on it as it used to have? Before I go there, however, there is a very interesting question about the medium term. The government has said that employers largely will be able to operate if they have social distancing measures in place. They've encouraged people to drive or cycle to work because we all know that trains are dangerous. What that doesn't deal with, however, is the question of the employee, perhaps a former commuter, who can't drive or can't work, can't drive or walk to work, and says, I want to work at home. I want to go on working at home as I've done so successfully over recent weeks. What will be the legal position here? Leaving Equality Act case on one side for a minute, the first question will be, what are the terms of the contract? Was the employer canny enough to vary the contract of employment in such a way that allows it to go back to how things were before? Because if they didn't, then there really are problems. And you'll all perhaps have heard horror stories of employers who agree to flexible working requests and don't insert a clause for review and a limitation with respect to time. So
Richard, it's worth stressing, isn't it, that a key concept behind putting your staff on furlough is consultation and agreement.
Yep.
And so there has to be a variation of contract.
Yep.
I mean, the concept of furlough has never really existed in English law. This is brand new.
Yep.
And we're going to come on to some questions in a moment, but it's worth stressing that there's no real law in any of this. It's something that the government kind of made up. And we're all trying to put it in the right pigeonholes.
Yeah. Yep.
It's all, can I just mention a few of the questions?
Yep, please.
So we've had quite a lot of good questions come in, so let's deal with that. What I think I'll do is I've got a take on some of them, and other people may have a different view, which makes it quite interesting. But this is often how lawyers are when you put a group of lawyers together. So I'll have a take, and it might be that Richard or the other lawyers have got a different answer on some of these. So the first question is, from Orang that once the furlough period ends, can I put the staff onto a 0 hours contract? And my response to that would be no, not unless they agree it. If they don't agree it, then you're looking at a redundancy. Richard, what do you think to that?
Well, I think that first of all, you have to try and agree it, and that's always the starting point, both legally and in terms of practicalities. Don't make an enemy where you don't need to. Secondly, an employer can pretty much always force through a variation, the number of ways in which an employer can vary a contract. In this case, the obvious thing to do would be to say to the employee, well, there are two things to do actually. One is to say to the employee, I'm going to give you notice on your existing contract, and I'm going to offer you a new contract like this. And a lot of employers will be doing that. There'll be variations of this question all over the country. If the employee accepts that new contract, funnily enough, they can still choose to sue you on their old contract for unfair dismissal. It's called a rule in Hogg and Dover Court. But the employer will win, more or less, if they have consulted properly. So consultation is important, in fact, the key.
And Orang had a second question. She asked, does any notice during furlough period count towards statutory notice? This, I think, is one of the interesting unanswered questions. My view on that would be yes, because you are still in work. You're merely being paid not to work, and so the employment contract continues.
I would agree with that. Yeah.
Next, we have a question from Violetta, who asks, as far as I can understand it, not because it's a badly worded question, it's just a complicated one, is on what basis is furlough pay calculated for staff prior to the 19th of March? So she says, for example, May furlough pay should be based on the pre-19 March pay and not on the current rate of pay, even when we increased it with the national minimum wage rules. I mean, that's a very interesting question. I don't think anyone's ever thought of that.
I think that, I mean, I agree with that, and I don't, if I'm being honest, I don't completely know the answer without further thought. But what I do know is that the scheme works by a series of bright lines. And a very good example of that is the way that you can't claim any furlough money if you do a single hour's work. Yes, no. And as I understand it, the scheme works by looking at the pay on the March the 19th. And what happens to it after that is not relevant. But to give an informed view on that, I'd need to go through the scheme again. But I'm very confident that's the position.
I think you're right. I mean, it can't really be any other way, I should think, because in essence, you're being paid not to work. So I don't think you as an employee could have a national minimum wage claim, because there isn't, I don't think unlawful deductions could arise in circumstances where the scheme is fixed. I suspect also that there'll be very sound policy reasons for it not to take place, because otherwise the effect would be people will be paid less. So I think I agree with you, Richard. The answer to that must be you've got to look at the old pay, not the new pay, unless you're topping up. Of course, if you're topping up, then I imagine you might have to top, certainly any hours above it, you'd have to top up, and you may want to top up extra for the national minimum wage increase if you're doing any kind of top up. But if you're not doing any kind of top up, I think you're only obliged to pay the previous amount. But that's a very interesting question. Thank you for that. So we have another question from N Turk, and he asks, or she asks, what is likely to be the position with the job retention scheme, furlough scheme, in light of the PM's announcement yesterday? Well, I did deal with that initially at the beginning, and the answer to that is nobody knows, because no one's said anything. There is some conflict, I think, in government, in that Business Secretary and the Chancellor have historically said it's going to end in a few weeks. The Telegraph, as Hans reminded me this morning, seems to think it's going to carry on till September. I frankly will be staggered if it carries on till September, because the cost is already enormous. I can't remember what the statistics are, but a very significant amount of the workforce is currently on job retention scheme, and I just can't see that the government is going to be able to afford to keep paying it. But certainly for all business owners, when you're risk analysing and business planning over the next few weeks, which is crucial, all clients I'm advising, we have to business plan all the time on our cash flow. One of the factors to bear in mind is simply that question of what happens if they bring the furlough scheme to an end. And I'm afraid all businesses need to work on the basis that it might come to an end in a month, or it might carry on. Each one, in fact, has its own risk and reward. Anyone have any comment on that before I move on to the next question? No, good. Violetta has another question. She asks, can employees insist on holiday bookings for furloughed employees by giving the correct notice? The ACAS guidance is not very clear. I personally think that they can, but other people might be less cautious than me. What do you think, Richard?
No, I think you can as well. I think it's Rule 15,
Yeah.
or 14 or 15, can't remember. Provided you work your way through the rules properly, the trumps, to use a card player's analogy, are with the employer.
Yeah.
And indeed, one of the things that I have thought of is that an employer will be well advised to use those rules so as to ensure that all holiday is taken up during furlough, so that there's no bill at the end if they decide to make redundant or untaken holiday pay.
I mean, the complication, I suppose, is if I recall the rules, I haven't looked at them for a while, but it's something like 2 days notice for every 1 day you want to ask someone to take. So if you want to ask someone to take 10 days, you've got to give at least 20 days notice. It can work out to be quite a lot of notice you have to give, if I remember rightly.
Yes, but although the number, I mean, we're dealing with a relatively small number of days during the furlough period.
Yes, no, that's true. Next question we have from Leah, who asks, would you furlough an employee who resigned recently, who has a job offer with another firm? I'm assuming you mean during their notice period. And I would say yes, but a lot is going to depend on the terms under which they left and whether they're working notice and the nature of your business. I don't think there's an absolutely bright line answer to that. What do you think, Richard?
I think that you could furlough someone who had resigned to take another job and then it was withdrawn because of the crisis. I think that's the sort of scenario we're looking at. I think you could. I think it's clear that you can from the guidance. The guidance explicitly says that the scheme covers those who have been dismissed and those who have resigned.
Right. Actually, Richard, sorry, could you come off sharing screen? People actually want to see the pleasure of looking at our lovely faces.
Do they? My goodness.
Yes, but the person who asked that's anonymous, so that might say.
Yeah. Okay.
Okay. Excellent. There we go. I hope that's better for everyone. Just a couple more questions we have. Orang's asked, can I ask another question? Can I bring back workers and put them on part-time hours instead? Now, I imagine what you mean is you've furloughed a full-time employee and you want to bring them back off full-time furlough as a part-time employee instead. And my answer to that question will be yes, with consultation and consent. It's not something that you can particularly force, but if you sat down with a staff member and said, look, either it's this or you're going to be made redundant, then they may take a view. Having said that, it's hard to see why an employee who's being paid a full-time furlough would agree to come and work for less money. That, I think, might be a practical difficulty.
Well, except that the employer could say, I've decided to terminate your contract for business reasons and replace it with a part-time one. And once you terminate the original contract, that gets rid of the right to furlough. I mean, it wouldn't produce a happy employee, but it would work from an employer's point of view.
Yes. Yeah, I mean, the more, I think you said this earlier, Richard, the more you consult with people and bring them on board to understand the decisions, the happier the staff you're going to have. The law always allows you to dismiss people for business-related reasons and re-engage them on different terms. The question is whether or not that is likely to be an effective way of dealing with it and managing your staff. But for some businesses, it might be the only way you can manage it. We have another question, and that's: can I still furlough a staff? Can I still put my teeth back in? Can I still furlough a staff as the portal is closed at the moment?
I didn't know it was closed, but you can certainly do so. The way the scheme works is the employer varies the contract with the employee so that they don't have to work, promises them 80% of the pay instead, or 2,500, pays that and gets it back from HMRC. If you are confident, as I think I would be, HMRC, any downtime on part of HMRC is going to be very brief, then there's no reason why you shouldn't do it at all.
Excellent. We're going to deal with just two final questions, which are more from the employee end than the employer end. But someone has asked the question, what if they're asked to come off furlough, but they don't want to because of childcare commitments? Can they choose to stay on furlough if their workforce reopens and essentially invites them back? Now, that is a very interesting question, and will no doubt generate a great deal of litigation in due course. I personally think that it's very difficult to resist being asked to come in to do your job. If you have to do it face to face, you can't do it remotely, and flexible working allowances can't be made. So there's going to be some scenarios where it's going to be very difficult. If you're in a client-facing position and you have to do that directly, it's obviously going to be much more difficult than if you are able to work remotely. What do you think, Richard?
I think that this would be a clear question of indirect discrimination. I'm assuming that the questioner is female. I could be wrong, but the stats say he or she is likely female, and requiring you to come back into work is more burdensome for you because of your childcare responsibilities. The real question is whether the employer has any alternative. And I think if the employer has good alternatives, there are 4 people who could be required to come and do this work, I think you have a strong claim. If they have no alternative, then it's difficult to resist it because they would have a justification defense. We need our employees to be in to run the business.
What I would say to the person who's in that situation is, well, wait and see until the end of the furlough period, because as I say, that could be in 3 weeks, it could be in 2 months. And what I would suggest you do is at the end, Tenny's going to mention that we're doing a free 30-minute consultation to people who've been to this webinar. I would suggest you definitely take that option, and as soon as you're in that scenario, jump on that and come on and have a meeting with one of the lawyers here and one of the barristers here, and then we can guide you, I think, much more specifically on your fact-based scenario. It's very difficult, I think, to answer those sorts of questions in the abstract, but that's why later on we'll tell you about this 30-minute consultation that we're offering to people. I'm just going to deal with one final question on some of these issues before we move on to looking at redundancy situations with Tenny. And the question is, my employer failed to give me any notice prior to quarantine, and one day before payday in March, I was informed orally that they're going to take it out of my holiday entitlement. Is this acceptable? As a result, I have no holiday left. I don't think that's acceptable, Richard.
Don't quite understand it, because quarantine is not the same as furlough. Quarantine is a big step. I'm
assuming furlough is what's meant.
Is it? Okay.
Yeah, that's my assumption on the question.
So
it looks like a day before payday, they were. The questioner was told that they had to go on furlough, and it looks like they were lost a day, which went on holiday.
It seems like it's a quarantine question, because that's why they asked. Like maybe then they were asked to go on there, but then they were the holiday was taken from that. Maybe that's what that person meant.
Yeah, I think I need to see more of the facts to be clear on that one.
Yeah, I mean, at first blush, an employer can only insist on holiday being taken with adequate notice, and for one day, you've got to give 2 clear working days' notice before you can insist on it. And if you haven't done that, then I think at face value, it's a breach. On the other hand, if it's the same questioner, because you're coming up as anonymous, you've said that you work for the Portuguese government, then there's a secondary question, which is whether or not you're protected under English employment law, or whether you're actually still governed by Portuguese law. That might be a suitable one to jump on and have a brief consultation on, because I think that's very, very fact specific, and it's very difficult to give much general advice other than that principle that as an employer you can't generally insist that your staff members take holiday without some significant hurdles to jump through in terms of time. All right, I think as time is pressing on, shall we move on now to Tenny, who's going to talk to us a little bit about redundancy, because of course that is the next stage along from furlough, and particularly in circumstances where furlough may end, businesses, you will be looking very much at the question of redundancy and the processes, to which Tenny will talk. Over to you.
Thank you, Simon. Hi, everybody. I'm just going to share my screen to show the slides. Everyone see that?
Yeah.
Okay, so I'm going to be speaking about both redundancy versus settlement agreement, and kind of a comparison of both. So we're starting off with redundancy. The definition of redundancy itself is much more detailed in the Employment Rights Act, but in short, it's where an employee is dismissed as redundant because the business is closed down, or if the need for the employee to carry out that particular kind of job has ceased or diminished. As mentioned a bit earlier by Richard, 2 years continuous service is required in order to qualify for redundancy pay. But the other potential claims that could come if, as a result of this not being done fairly, is protected characteristics under Equality Act, as Richard was mentioning. So what protected characteristics mean specifically is it could be racial, sexual, disability, religion, pregnancy, for example. And I think in this situation, there's a particular need to be very careful of how you deal with the redundancy procedure to make sure that the fairness of it is not in any way affected. So the process and the time frame very much does depend on how big the company is, how many employees it has. But as a general overview, in terms of the procedure, firstly, the need to consider why is there a redundancy? So going back to the definition, is it as a result of business closure, or has the particular job completely diminished and ceased? And given this current scenario, there has been quite a few of these. So that's the first thing to define. Secondly is the consultation stage, where all those who are at risk of redundancy are informed, are given notice, and then individual meetings with each person is conducted. So why the redundancies are being made in the business needs to be explained to the employees. And why they are being considered, what are the alternatives there could be for them in the actual job. So what would be the other considerations they could have? For example, is there a different type of job that they could be doing with different jobs, skill sets that they may already have themselves? So that's quite an important consideration. And looking at this and giving the employee the opportunity to make their own representations on why they should be retained. But going through it fairly and consistently is quite important for all for the employer to ensure that there is a fair process in place. There is a need to also, when you are having individual meetings with employees, that they could be accompanied with a trade union rep or a employee, which is quite important to be considered. If the process itself is not dealt with fairly, if there isn't consideration given to all of these points, there are potential unfair dismissal claims that could be brought as well against the employer. So there is quite a lot to consider, and there is quite a few steps to take during the consultation processes, and it can take time if it's quite a large number of employees that are being considered. So these are quite important steps, and to avoid claims being brought, these steps need to be taken very closely monitored and carefully dealt with. In comparison, settlement agreements is another option for a lot of employers, or what was called compromise agreements. It's a legally binding agreement between both employer and employee. Once it's signed by all parties, it would stop the employee from bringing legal action against the employer in respect of their employment and in respect of how it was terminated. And in exchange, there is termination payment made by way of compensation, and other benefits are given under the agreement. The employee will usually have it's tax efficient for them. It's quite attractive. I believe up to 30K is tax-free under the termination payment section. It's obviously notice pay has the usual NI tax deductions, but the termination payment itself, the compensation amount, is not taxed, together with a job reference, clauses for the employer and employee not to speak in derogatory terms about each other, plus various other different clauses as the employer would like to add. It will safeguard them against future legal claims being made, and it's that is probably the biggest attractiveness of a settlement agreement for an employer. There are a few exceptions, very few exceptions to legal claims being brought against the employer, but majority of claims could not be brought. The process is quite quick in comparison to redundancy. So setting out the terms of the settlement agreement, providing this to the employer, asking them to take, employee, asking them to take independent legal advice by a qualified solicitor. Then the solicitor gives them the advice, signs a certificate confirming this, both parties sign the agreement, and the employer simply follows the terms and makes the payments as set out in the agreement. These settlement agreements aren't just in redundancy situations as an alternative, but it can be in numerous other circumstances. So a lack of performance. So for example, somebody could be working for over 2-year period and has therefore got the qualification period, but their performance is lacking, and their settlement agreement could be another alternative instead of going through a disciplinary procedure with them. Long-term sickness, clash of personality sometimes, a means of settling a grievance, a transfer of business. Right now, especially, employment tribunal claims are very lengthy, are very uncertain, potentially could cost a lot for both parties. So this is quite a good alternative for some employers, and it's amicable, it's quite speedy in most situations. And just summing up, as I said, it's a quick and safeguarded way for employers to have a settlement agreement. But obviously you have to balance that against, it can be actually an expensive route as well. And you do need to consider whether the employee will accept the compensation payment. And if they don't, it does go back to square one and having to go through all of those processes. There's quite a lot to consider there. But if any of these aspects are things that you're concerned about, then please get in touch with us. Like Simon was saying, we're doing a free 30-minute consultation with anybody who would like to ask us questions. Email us at info@otslisters.co.uk. That's it for me for now. I'll be back a bit later, but if there's any questions anyone has now, feel free to ask.
Thanks a lot, Tenny. I mean, two things I've noticed as a barrister that tends to come into cases much later is that redundancies are quite good cases in many ways for employers. If you follow the process properly, I've found that it's very hard to win those claims as an employee. It's just difficult because the law allows for institutions to make staff redundant, and it doesn't often even look behind the reasons for the redundancy unless they're what's called a sham. And so it is a pretty good process. If you follow it properly and in good faith, it's very hard to win those appeals as an employee. Has that been your experience, Richard?
Yes, I think it is. It has been very much. I think I'd like to just add one thing there about settlement agreements, which is that it's worth often offering a bit more money than the minimum.
Yeah.
So there is a statutory redundancy scheme that has a formula for working out how much employees will be given as redundancy, and you have to pay that. But it seems to me that it's on the whole not usually terribly sensible just to offer a settlement agreement with that sum in it, because why would the employee sign it? And again, it's worth thinking when you contemplate giving a bit more, how much you'll save in terms of time by getting that compromise agreement solved. If a dispute develops and you use up 3 or 4 hours of lawyer time, you're going to be looking at £500, £600, £7 straight off. It's worth a great deal to put that up front into the settlement agreement to get the employee to sign it.
The one question we do get asked quite often, how much in terms of termination payment? Because there's no particular rule about this, so, and it's a lot of it is discretionary for the employer. But as a general rule of thumb, is there something that you'd say is the amount?
I think it's, in some respects, a question that your client is better placed to judge than we are.
Yeah.
They know the employee's circumstances. They know whether £5,000 it matters enough to get them to sign the compromise agreement, and we don't.
I mean, they usually look at it based on the years of service and how many years of service, how many months of pay they should get.
Yeah, I mean, a lot of employers just offer enhancement on statutory redundancy.
Yeah.
So that they take the same formula, but instead of putting in the statutory sum per year, they put in that plus 50%.
Yeah.
But it's, in the end, it's just down to money.
Yeah.
With higher paid employers, particularly higher paid employees, particularly higher employees who are being taken out, and who the employer wants to declare redundant, what they often do is offer a lot more money, but just a bit less than the employee could get through an unfair dismissal claim. So if you've got a very high paid employee, sometimes the employer just decides to take them out, no pretense at process, we're getting rid of them. And they're from the start, they're counting on a settlement. Well, what they do is say, well, look, yeah, we know we didn't follow the process. We know that there's an unfair dismissal claim. We know it's worth about £85,000. So we're going to offer 60, just to make it not worthwhile going to tribunal. But that sort of thinking only really matters with a higher paid employee.
It's an art and a science, isn't it, these sums?
Yeah.
If you pay too much, you might encourage a whole load of copycat claims. If you don't pay enough, you risk insulting and enraging the employee and making the situation worse. You have to picture it at a level which is sufficient for that staff member to not want to take it to tribunal. But a lot actually does depend on quite an objective analysis of how good your case is as an employee, because a lot of people take claims to the tribunal who don't have good claims because they want a settlement, and it becomes just a commercial bartering aspect. But you also have to look beyond that to think, well, if I settle this person's claim at 10 grand, do I have 10 other claims to settle at 10 grand? So it's an art and a science, and there's no easy answers. As Richard says, the clients often know the answers, but they often struggle too because of the whole logistics and all the different facets that juggle into it. The one thing I wanted to stress perhaps on settlement agreements is that it's one of the few areas of law which lends itself least to do it yourself, because settlement agreements are absolutely prescribed in their content in law. There is a very strict set of requirements, and if you don't have a settlement agreement that actually complies with all of those, it's not enforceable, and that can be a huge problem, because you could give your member of staff 50 grand in a settlement, and then a week later you get a claim through the post because your settlement agreement wasn't compliant. And the law moved a good few years ago to try and uniform the standards of settlement agreements, because a lot of staff members were saying we didn't understand what we were signing away. And that's the big problem with settlement agreements. So they have to be prepared really very accurately and compliant with all the different cases and pieces of legislation. Otherwise, they're almost valueless. Have you ever unravelled one, Richard, as a matter of interest?
Yes, I have. It's coming to trial next September.
Excellent. You see, there we go. The classic example of what happens for a member, for an employee or an employer who drafts a compromise agreement, but it's not compliant. It's not fun. Right. On that note, let's move on to the next topic. The next topic I wanted to briefly overview was government assistance, and because time is pressing us, I shall do this very, very quickly indeed, and I can do it in 5 minutes or so. So I hope you can see my slides here. Can someone just tell me whether they can see my slides?
Yep.
Yep.
Okay, perfect. So essentially at the moment, we have about 6 aspects of government support and help which exist for businesses: grants and loans, business interruption loans, employee wage support, deferred tax payments, mortgage and rent support, and hospitality and leisure industry has its own special requirements. We're going to make these slides available in due course, but there's a link here, which if you go to is the most accurate, up-to-date list of what the government is doing. And it's fair to say that this is the most unprecedented amount of government assistance given to small businesses in history, I suspect, in reality. Grant support, well, all of you who are entitled to grants will have them by now. So this is perhaps old-fashioned. It's all done through the local authorities, and they would have written to you directly. I've spoken to a few businesses and they've already had the payments. So if you haven't had contact from your local authority and you think you meet the eligibility requirements, then you should be contacting your local authority. One second. Sorry, thank you. The retail, hospitality and leisure industry is the one that in generally is going to be most affected by it, which I've listed on that slide. You don't have to apply for it. Your local authority will contact you if you're eligible. There isn't a lot of guidance on what to do if you think you're eligible and the local authority haven't contacted you. I suspect it's write and complain, challenge it through the complaints system, and then you'll have to take what's called a judicial review in due course. But hopefully most of you won't have to go down that line. The key thing is whether you pay business rates and what's the rateable value of your property. And if you haven't heard anything from the local authority, it might be because you fall, either you don't pay business rates for your business premises, or you're above the specified amount. So that chart there sets out the rateable values. Under 15,000, you're entitled to a £10,000 grant, and 15 to 51,000, it's 25,000 per property. There is a link which takes you to the hospitality section on business support. I've got gov.uk, which is a very good government website on these things. The business interruption loan scheme, I don't think has worked as much as it should have done, but the business interruption payments will cover the first 12 months of interest payments for any eligible loan, which is guaranteed by 80% or 80% of the loan. The problem, as I understand it from clients, is the banks simply aren't lending in the first place, so it all becomes a bit academic. But in theory, here is a list here of the current government accredited lenders and partners. They have said that they're not asking for personal guarantees, although I've had clients say that they are. And they've also said that the government will pay 80%, although that's not being factored in, it seems to me, in the granting of loans. So I think we are in a similar story to where we were in 2009, which is the banks just not lending, even though the government wants them to. But it's well worth checking that out. If you meet the eligibility requirements, and particularly if you have good relationships and good credit, then that exists. Yeah, the big four banks have said they're not going to ask for personal guarantees for loans of less than 250k. If you have applied and you're asked for one, then refuse, because I imagine the banks will try and slip through. And this is what some clients have said to me. The banks have tried it on with the personal guarantee, and then when it wasn't granted, when they didn't agree to it, then the loans have been granted. You still need a solid business case, by the way, for it, which means you still need to be asking or presenting a sound reason why you need the money. You can't just bung in an application and ask for it. And it's for companies with a turnover of less than 45 million, which I suspect is a lot of English small businesses. Business rates relief kicks in here. It's part of the package for small businesses. Your local authority will have contacted you already, in particular for hospitality and the leisure industry. If your rateable value is less than 51,000 and you're a shop, restaurant, cafe or pub, then you will get a third off, and there are other localized forms of relief as well. There is also small business relief for non-hospitality rated businesses. So that's a very swift overview of the government schemes that exist in terms of loans and grants. I've done a couple of summary slides. I'll make these slides available. Don't forget, we've talked about this as well, of course. The job retention scheme is designed as much to assist businesses as to assist employees. We've talked about that at great length. There is some SSP relief as well, so you can reclaim money on statutory sick pay. Also think about alternative funding, crowdsourcing, peer-to-peer lending, asset finance. Government have also deferred tax payments for businesses with time to pay arrangements. The March 2020 Q1 VAT payment is going to be deferred automatically for 3 months. And for any of us who pay self-assessment, the July interim payments are deferred until January. Of course, we all know that the government have given 3 months rent relief from eviction for commercial and residential tenancies and mortgages. And I understand that banks are being quite cooperative, and our other lenders, has certainly been my experience, with granting relief from payments. So there is a very large catalogue of packages in place to assist businesses. And I'm now going to turn to some of the questions. Orang asks the very good question, which I touched on, which is what happens if the local council refuses the small business rates relief grant or application? Can we take legal action? Yes, is the short answer, if they refused it wrongly. I haven't yet seen a formal mechanism for that to be challenged internally or externally for that matter. So I imagine it would have to be from a judicial review. But if that is a situation that has arisen, then I would definitely suggest you take up the 30-minute consultation and speak to one of the team here, because that will require looking at in some detail. We're also asked the question, which I have talked about on other webinars, which is there any support or relief for charities? There hasn't been much announcement for help of charities, and this is cutting a swathe through charities, in that art galleries, a lot of small charities that deal with community projects are facing decimation. The government have made some noises about giving grants to charities. I think they announced last week something like 3.5 million or something, but the actual assistance that's been proposed for charities at the moment has been virtually insignificant. I suspect there will be more packages to try and help charities when the government realises how many particularly outreach projects may fail. But a lot of charities in the arts in particular are facing absolute crisis as their income has completely gone. And it's one of the big problems. I think we're going to see a lot of charities go to the wall at the moment because the government just simply haven't got round to thinking about relief for that sort of that sort of organisation. I suspect they thought that they didn't need to, but when they realise the tsunami of problems that will probably come along when hundreds or thousands of charities that do good work in the communities collapse, then they will revisit the matter. But so far, there haven't, as far as I've seen, been any detailed plans or any assistance given to charities, which is obviously a huge problem. Right, so that was my quick dance through. I did that very quickly of support for businesses, because I imagine all of you on here who have businesses will largely have taken those up. If you want a bit more structured help and advice on funding and packaging, then again, take up the 30-minute consultation. The most critical thing I would stress at this stage is to think about cash. It's so important that businesses get into cash as quickly as possible, as cash is king. Most businesses don't collapse because of a lack of work. They collapse through a lack of cash. Now, the government, as you may have seen, have suspended the wrongful trading obligations on directors, which allows companies to potentially trade whilst insolvent during this time. But that's not going to be a get out of jail free card by any means. It also doesn't mean, as I had to explain to a client recently, that they can simply empty the business bank account into their own bank account and close it without repercussions. That's not what that scheme is designed for. But businesses must get into cash. And one of the things that all of this focuses on, furloughing, redundancies, government schemes, grants and loans, is getting companies into a position where they have some form of cash flow enough to get them through to next August, September. And that really is the critical thing. The unifying theme behind all of these presentations is very much get into cash. A business that can get into cash and has some form of liquid cash flow is likely to make it through the next 3 to 4 months. And that's what all of this is designed to go towards. So that's all that I wanted to say on those matters. I'd like to then ask Hans, who wants to talk to us now about preparing for post-COVID-19 and the wonderful sunny uplands that await us when we go through this period. Over to you, Hans.
Thank you, Simon. I'm just going to share my screen now as well, so please bear with me. Yeah, can you see it?
Yep.
Yep.
Yeah, so my topic will be about good practice steps for employers. Like we know, all employers have a duty of care towards the employee, and they have a legal duty to maintain health and safety. My colleague Stephen as well will talk about health and safety later on after me. So the employers must take all reasonable steps to protect employees' health and safety, provide clear and accessible communication about the likely risk, and take a supportive view of those who have caring responsibilities. Employers can also provide opportunities for employees to discuss their concern with a line manager or an occupational health or counseling service. We have heard during this webinar that potentially there might be loads of concern from employees, even if they need to go back to work. So should they go or should they not go? So we might think that there will be loads of litigation in that field. So this means that employers, they need to take all reasonably steps to support the health, safety, and well-being of the employees. So maybe they need to set. We have heard from the government that they will have a COVID secure for all employers. I think we need to wait for that to be able to see the guideline from the government. Some of the good practice, which I've tried to, we have put together at the employment team at OTS Solicitors. So we have said that, everybody needs to make sure that social distancing if they come to workplace, because this is in line with a government announcement. Even yesterday, they have said that it needs to continue. Be especially careful and take extra steps for vulnerable group, including those who are pregnant. I think we had a question today about a lady being worried going to work. So maybe a good option would be to speak to the employer directly to raise the concern and express the concern why she's scared to go back to work. Hold meetings as remote calls and avoid travel as much as possible. So again, this is in line with what the Prime Minister announced yesterday. Again, we don't know how this is going to work, telling people to go to work. And then we know that in London, loads of people use the public transport. Not many people can cycle, especially pregnant women. So again, this needs to be a talking point in the company. So make sure managers know how to spot symptoms of coronavirus and are clear on any relevant processes. For example, like, the process will be a bit different where people used to report the sickness in terms of sick pay. So there needs to have procedure in place to be able to deal with that. And I'm sure that Tenny later on will explain how we can assist companies in having like talks, guide from us in order how to implement them changes. Make sure there are clean places to wash hands with hot water and soap, and encourage everyone to wash their hands regularly. I mean, like, this is the basic, and I'm sure that company will encourage the employees to do that. Provide hand sanitizer and tissues for staff, encourage them to use them. One of the solution that we can see to observe this health and safety. Make sure that everyone contact number, emergency contact details are up to date, because you never know if there's an emergency at work. You need to contact the next of kin. Sometimes employers tend to forget to update that emergency contact, but I think it's high time to review all the files as well. Keep everyone updated on action being taken to reduce risk of exposure in workplace, and keep up to date with the latest government advice. I think like today we're expecting the Prime Minister to come with further announcement. I mean, like, while being on the webinar, I've just heard that football will start from the 1st of June, which is always good for the country. And then we have the end. So, I mean, like, we were discussing about like furloughing. I saw a very good article on the Telegraph where there's talk that the scheme might be extended, but then this is again to be seen. But we need to advise and we need to plan as if like there is an end of the furloughing and people need to return back to work. So some of the key thing that we think will help companies dealing with the post-COVID-19, we think like business planning should be a main topic for companies. By business planning means like, they need to analyze, they need to plan. I mean, like, what will happen? Will you be able to reintegrate all furlough employees back into the business on full pay immediately, or some only? What process will you follow to bring employees back to furlough? If you do not have enough work to bring back all furloughed employees immediately, are you able to keep those who you cannot bring back to payroll temporarily? So all this needs to be planned, and I mean, like, management level needs to have a plan in place to be able to tackle that. Then we have the health and safety, which my colleague Stephen will talk about. But again, it's like it's very important to know how this will happen. The testing. I mean, like, when colleagues are going back, I understand that there will be an NHS tracking app. How we're going to implement that in workplace. So there's quite a few things that needs to be taken into account. So Stephen will address that and then next after me. Then we have redundancies. Again, I think Tenny spoke about redundancies. I mean, like, how this will happen, because let's be honest that there will be quite few companies that will suffer in the UK. So how will they do that? How will they conduct the meetings and stuff like that? Because potentially, if they don't follow the process, there might be claims and in the ET. So it's quite important to know how companies will be dealing with that. I mean, like, if you're planning to do it at a large scale, so again, remember there's an obligation, I mean, like, that company's directors needs to take into account just to avoid wrongful, unfair dismissal. And then the next things, which is very important, is about avoiding discrimination. So how you're going to make decision, and then which will not be, it might raise an issue of discrimination at work. So Stephen will cover this as well. But like I said, and we have been saying that, we are going to explain how at ETS solicitors, together with the barriers that we have at 36 Group, how we can help companies to like maybe to address and to implement certain procedure and certain rules in place, so that we can get back to work as soon as possible. I will leave that to Stephen now to explain about health and safety and the discrimination side of things. Thank you.
Thank you. Right, I think you have to unshare yours, Hans, before I can share mine. Right. Is the shared screen visible now? Oh.
Not yet, Stephen.
Okay. There we go. So there was discussion on Radio 4 this morning when the General Secretary of the Unite Trade Union was questioned about actions that employees might take if they felt they were being asked to return to workplaces which were unsafe. And discussion was bandied around in terms of employment protections which those employees might potentially lay claim to. And reference was made to Section 44 of the Employment Rights Act, which provides protection to employees who have a designated responsibility for health and safety. So they enjoy protection from any detriment by an employer if they enjoy that designation. But that should not be elevated to the concept that anybody can walk away from work if they have a perception that for reasons of COVID safety, that they are at risk. And the more relevant provisions for people returning to work for the first time will be where potentially they have a claim for unfair dismissal arising out of raising health and safety concerns. So Section 100 of the same statute of the Employment Rights Act has broadly three categories of protection. That is Section 101C, which deals with a dismissal where the cause of the dismissal was raising health and safety concerns through other means. The more relevant provision in terms of current discussion, as far as automatic protection, is where the employee can argue that there is a serious and imminent danger. That's the test in Section 101D of the Employment Rights Act. And a dismissal in those circumstances would be automatically unfair. And now the final protection concerns employees who were subjected to dismissal for taking action to prevent a foreseeable danger under Section 101E, where employees had reported their concerns about COVID-19. Now, theoretical protections of that sort are all right in theory, but very difficult to prove in practice, because the epidemiological research in terms of what constitutes a risk at work at the moment is an unknown. So there could, as Hans was referring to earlier on, there can be people who are in vulnerable groups, asthmatics, pregnant women, people with pre-existing lung conditions, maybe even heavy smokers. All of those people are potentially at increased risk. So if they were to raise a concern with an employer to make a reasonable adjustment, then potentially, because those are congenital conditions, that could give rise to a disability discrimination claim if the employer didn't make appropriate safeguarding steps. For example, to allow somebody who enjoyed one of those vulnerabilities to engage in remote working as compared to their younger and fitter counterparts. I think the final thing that I wanted to draw attention to was actually probably the more appropriate stance for an employee to take is, if they had concerns about the workplace being potentially a COVID unsafe environment, that they should raise those concerns with the employer under the whistleblowing provisions, because to raise the concerns then would amount potentially to a protected disclosure. And then if the employer subsequently took, if you like, retaliatory action against the employee for raising a protected disclosure, then they would have potentially a much more simple to prove claim than they would do in the three other health and safety protected clauses in the Employment Rights Act. But I'd very much welcome Richard and Simon's observations on how they think the whole subject of the hazard of returning to work is going to be navigated in employment law.
So Richard, do you want to take the first hour on that, and I'll take the second hour on that?
I'll take the protected disclosure avenue to start with, because I've got a case just like that. I think in many ways I don't want to add a lot to what Stephen has to say. You just have to reasonably believe that the employer's action creates a risk to health and safety, and you have to tell the employer about it. It does have to be a public interest disclosure, and there's been a lot of i.e. in the public interest, not just about yourself. But it's pretty easy to make the disclosure in a way that makes it public interest. I believe that the health of myself and everybody on this work floor are in danger, so there wouldn't be too much of a problem there. One of the very attractive things about a protected disclosure is that it is one of the very, very few claims in employment law which is subject to interim relief, i.e. if you have a very strong claim of that kind, the Employment Tribunal can order you to be reinstated with immediate effect, which in the current climate is an incredibly important remedy. It's quite difficult, so employment lawyers think, to do that, to win, because you have to show that you're likely to succeed. But if on the other hand you've sent an email to your employer saying the sorts of things I've just outlined, and then the next day you're shown the door when there was no previous hint that you were in trouble in the workplace, I think a tribunal in the current climate in particular would have little trouble satisfying the test and allowing you to be reinstated. So, sorry?
7 days though, isn't it?
You've got to apply within 7 days. You got to, I mean, yeah. But you may get it, you may not, but it's a tremendously worthwhile target for you and your lawyers to shoot at. As to the others, I think I'll leave Simon to talk about those.
I think one of the most complicated aspects of the next few months will be taking staff off furlough and managing return of employees safely back to the workforce. I think it's going to be one of the most complicated things that to be done, and if not done properly, is going to engender a lot of bad faith, a lot of bad feeling, and also potentially quite a lot of litigation. It has to be handled with great care. There has to be a lot of thought that goes into it, bearing in mind government guidance, but also the needs of the business. And businesses need to start planning for that very process now. And that's my advice to business clients right now, is you need to start to really have a very strong plan in place to get your staff back off furlough and back into the workforce or restructure. Because if you wait for the government to tell you that furlough is ending next week, or that furlough or the lockdown is going to end in a few weeks' time, if you get that sort of notice and you've not put a plan in place, you're already considerably behind, and that's going to cause a huge problem. So I agree with you, Stephen. I think it's going to be one of the most complicated issues that will face us all going forward in the next few months. Tread carefully.
Thank you.
Tenny,
yes.
do you want to draw us to an end?
Yes. So just to thank everybody for listening. Actually, whilst we've been speaking, there's been a few more updates coming on the news. Face coverings being given, advice being given to everyone to have face coverings in public transport and in shops from Wednesday this week. So these are coming in quite quickly, and I think today there's going to be more details announced in Parliament. But we've had, as a result of all these announcements, we've had quite a big rush of employers contacting us with a lot of concerns over what to do with health and safety aspects and the Section 44, as Stephen was talking about. So if you do have concerns, if you have any further questions, like we've mentioned, please contact us, info@otslisters.co.uk for the 30-minute free consultation. We also have a COVID-19 audit report that we can prepare for employers, and we can provide this to prepare for cases of restructuring, of redundancies, consideration of staffing issues, health and safety. So again, contact us if you would like to get this service as well. And just thank you to all the panelists as well for speaking today.
Excellent. Thank you for that, Teddy. Well, unless any of our attendees have any last minute questions they want to rush in to the webinar chat, I'll just give people a few seconds to, or put your hand up if you want to in the participant list, and then we'll know you've got a question. Just give people a few seconds. Nope. Well, we've run almost an hour and a half, so that may be enough time. As Teddy said, please get in touch if you want your free 30-minute consultation, and if you would like to take advantage of the joint OTS 36 group audit, please get in touch with OTS solicitors. I think you'll find a lot of benefit out of this. We can help go through your exact business needs, looking at things like cash flow, restructuring, redundancies, and try and help you get on track to get ready for what may happen in the next few weeks and months. So it's a good offer that's being run at the moment, and I would strongly encourage you to reach out and take advantage of that. So with that note, I'm going to draw this webinar to an end. Thank you very much, all of you, for coming on, and I hope you all have a good day. Thanks.
Thank you.
Thank you.